La Cour Please be seated. I declare open this public hearing of the Grand Chamber of the European Court of Human Rights for the delivery of the court's judgment in the case of Yasak against Turkey, pursuant to Article 44 of the Convention and Rule 77, Paragraph 2 of the Rules of Court. The hearing is being broadcast live on the court's website. The parties have been duly informed of the date and time of today's delivery. The government are represented by Mr. Yilmaz and Mr. Selamir, legal consultants of the permanent representation of Turkey to the Council of Europe. I welcome the representatives in the name of the court. The judgment delivered today concerns the application that was lodged by Mr. Yasak on the 2nd of April 2020 under Article 34 of the Convention. The Chamber of the second section gave its judgment of the case on the 27th of August 2024. It examined the applicant's complaints under Article 7 and Article 3 of the Convention and found no violation of either provisions. The applicant then requested referral of the case to the Grand Chamber under Article 43 of the Convention. His request was accepted by the panel of the Grand Chamber on the 16th of December 2024. The following parties were granted leave to intervene in the proceedings before the Grand Chamber: the UN Special Rapporteur on Counter-Terrorism and Human Rights, the European Criminal Bar Association, and the Italian Federation for Human Rights. The interveners made written submissions on the case. The Grand Chamber held a hearing on the 7th of May 2025. It adopted its judgment on the 11th of February 2026. I shall now provide a brief explanation of the facts of the case and of the court's assessment of each complaint. The Grand Chamber has first assessed the complaint under Article 7 of the Convention. This complaint arose out of the applicant's conviction of the crime of membership of an armed terrorist organization. That organization is referred to by the Turkish authorities as FETÖ PDY, and they hold it responsible for the attempted coup d'etat that took place in Turkey on July 16. The domestic courts convicted the applicant of this offense on the basis of a range of evidence against him. In particular, the evidence included witness statements to the effect that, over a number of years, he had been active in the organization's educational activities, rising to the rank of principal regional student leader in its covert structure. In that capacity, the testimony given was that he had supervised students residing in houses belonging to the organization, that he had recruited students on the organization's behalf, and that he had propagated its ideology. It was also testified that he has used a code name when conducting these activities, which took place between 2010 and mid or late 2014. The applicant was sentenced to 7.5 years in prison. The Grand Chamber's judgment recognizes the unique challenges faced by Turkey from this organization and its duty to protect the lives of its population against terrorist attack. However, even in such a situation, the state must fulfill the duty to protect human rights and respect the fundamental safeguards ensured by Article 7. It is a non-derogable provision that has to be complied with also in the most difficult of circumstances. In that regard, the Court's judgment confirms that Article 7 protects the right for the individual not to be punished without his personal liability having been duly established. This involves a number of interrelated principles. First, there cannot be collective guilt or guilt by association. Second, there must be proof of the material acts that constitute the offense and also proof of the relevant mental link, the mens rea of the offense. Third, there is a clear correlation between the foreseeability of an offense and the personal liability of the offender. It is made clear in the judgment that the court's examination of the complaint is based on the facts as found by the domestic courts. It rests on the premise that the applicant committed all of the acts established in the proceedings against him. The relevant question for the court is whether these acts fell within the definition of a criminal offense that was sufficiently foreseeable. Applying the general principles, the judgment examines the mens rea requirement of the offense as set out in the domestic law. This required it to be shown that the defendant was aware at the relevant time of the organization's objectives and final methods. According to domestic case law, it must be established that the person acted knowingly and willingly, that they wished to be part of the organization and demonstrated a continuous willingness to belong to it. The court considered this to be all the more important because of the presence of the organization in Turkish society for a considerable period of time. It was essential to avoid any finding of guilt on the basis of mere association. Particular rigor was therefore called for, with two aspects being very relevant in this regard. The first aspect was temporal. The judgment finds that the necessary rigor was lacking in the judgments given in the domestic proceedings. The relevant time period for the applicant's membership of the organization was not clearly indicated. In any event, it came to an end quite some time before the attempted coup, and therefore the organization was officially designated as a terrorist entity. In light of this, the domestic courts were under duty to assess whether the applicant's involvement could be regarded as deliberate and conscious adhesion to a terrorist project. But they did not explain why his activities were such as to establish beyond reasonable doubt the necessary mens rea. The second relevant aspect was the applicant's involvement in the educational branch of the organization. This was because the organization had been present in the field of education in Turkey for many years and had operated legally there. For this reason, it was all the more necessary to conduct an individualized and contextual assessment of the intentional element of the offense. It was necessary to establish an actual link between the applicant and the organization's central or strategic components, and also to establish the nature of that link. That was not done, however. The courts did not ascertain either the extent of his responsibilities in relation to these other branches or his knowledge of the terrorist objectives at a time when no act of violence had been attributed to the organization. The mere fact of belonging to a structure that was largely perceived at the time as a religious group could not, by itself, lead to the conclusion that the applicant had the necessary mens rea for the offense of membership of an armed terrorist organization. The domestic courts merely listed the evidence and then drew their conclusion. They did not explain how it had been established that the applicant had joined and remained part of the organization with awareness of its terrorist objectives. The failure to assess mens rea in light of the specific evidence about the applicant's actions and role was a fundamental breach of the requirement to conduct an individualized assessment of criminal liability. Such an approach violated the individual right not to be punished without the existence of a mental link through which an element of personal liability must be established. The second complaint in this case was raised under Article 3 of the Convention and concerned the applicant's conditions of detention in prison. It complained of being held in very overcrowded conditions for a period of just over 4 years. In particular, it complained that as there was not enough beds, some mattresses were placed on the floor in the common areas. The prisoners organized a rota system, alternating between the beds and the mattresses on a monthly basis. Over a period of 4 years, the applicant spent a total of 14 months sleeping on a mattress on the floor. The judgment refers to the lack of privacy with this arrangement, the permanent exposure to artificial light, and the disturbance of sleep due to the noisy atmosphere. These factors affected the sleep quality, leading to physical and mental fatigue. Endured over a prolonged period, this must have been a heavy physical and psychological burden for the applicant, it finds. It was also manifestly contrary to the principle previously stated in the court's case law of one prisoner, one bed. This aspect of the prolonged and serious overcrowding was examined together with the other factors, including inadequate sanitary facilities and very limited access to outdoor exercise. The judgment finds that the cumulative effect of all the circumstances was to subject the applicant to treatment that attained the minimal level of severity of Article 3 of the Convention. Having explained the court's reasoning, I will now read from the operative provision of the judgment. The court, point 1, dismisses unanimously the government's request for re-examination of the decision by the panel of the Grand Chamber. Point 2, dismisses unanimously the government's objection of inadmissibility alleging an abuse of the right of individual application. Point 3, dismisses unanimously the government's preliminary objection alleging failure to exhaust domestic remedies with regard to the conditions of detention. Point 4, holds by 11 votes to 6 that there has been a violation of Article 7 of the Convention. Point 5, holds by 9 votes to 8 that there has been a violation of Article 3 of the Convention. I will not read out the remaining operative provisions 6, 7, 8, and 9, which concern the issue of just satisfaction. It is sufficient to say that the court has awarded the applicant compensation for the non-pecuniary damage suffered as a result of the violation of Article 3. Following this hearing, the full text of the judgment in English and in French will be published on the court's website and will be available in the UDOC database. There will be also available a legal summary and a press release prepared by the court's registry. This public hearing has now reached its conclusion, and I declare it closed.